All right, sir.
Thank you. May it please the court. My name is Bruce Edmonds. I represent Willie Cater and Gloria Cater, who are husband and wife, who are the plaintiffs in the underlying action and the appellants and cross-appellees in the matter before the court. The circumstances which bring us here today started in 1899 in Truro, where Charles W. Cobb owned a large tract of land on the western shore of Cape Cod, bordering Cape Cod Bay. And in 1899, Mr. Cobb carved out about a 3.5-acre parcel in the northwest corner of the property and deeded that lot to a Lorenzo D. Baker, reserving all of the land to the east and south, which remained in the estate. In creating this deed, Mr. Cobb granted to Baker a right-of-way described as over my land on the east in the road now established. At the time the deed was executed, there was a proprietor's way along the eastern border of the Cabot estate, which has since become a Fisher Road, and we allege that that was the way that was referenced in the underlying deed.
When your clients bought this property in 1979, they obviously didn't build anything on it and didn't seek, is that right? They didn't seek to build anything on it until 1998? Is that?
Until approximately 1997, correct.
97? So how did they get to the land?
That's an interesting question. Because there was never a structure on the land from the date the parcel was first created until this day, there was no reason to go on the land for any particular purpose. There's never a barn.
Something they bought it for a reason.
The Caters bought it for a reason,
right,
to develop it. But the point is that because there was never a structure on the land, there was no reason to go onto the land with any degree of regularity. And people who did go on the land approached it from different locations. Apparently, the Cobbs owned a piece of property to the south of the lot itself.
East. And southeast, right?
Southeast, correct.
Right. So that's that driveway?
If they went up onto the dune, they would go from that location, apparently.
Did they look at the land before they bought it?
They did.
How did they get there?
I'm not sure exactly. They went down to Benson Road, and I don't recall directly how they approached the land.
Is sort of more of a merit of curiosity than anything. Cobb retained this other large parcel and then gradually sold it off, I take it?
I think that's essentially correct, Your Honor. I think what happened is that, in fact, his wife...
Let me ask you another question,
Sure.
so that you can fill in. As these conveyances were made to other people out of the larger Cobb parcel, was any reference made to the easement that was contained in the Cater deed?
Apparently not.
Never.
Wasn't there some reference to the easement that goes from the Cobb homestead? In other words, in the southeast?
When the Caters received their deed contained a reference to the 1899 right-of-way, and also a second right-of-way to what is called Stevens Way across the old Cobb homestead.
Okay.
The rural road alternative, your brothers say that with regard to the 12 feet, there is a 14-foot requirement of the subdivision, and that cannot be waived, and therefore your 12 feet is simply not going to fly, even if there is the rural road alternative. Do you agree with that?
Well, our position is that when the land court restricted the width of the roadway to 12 feet, it essentially led to the conclusion that the Caters cannot build a right-of-way or cannot build an access road that will meet the subdivision and zoning regulations of the town of Truro, because whether the road is used as access to a single lot subdivision or what's called a right of access over a right-of-way. Either way, the road must be built in accordance with the Type A requirements, which is a 14-foot roadway, and with a grade that won't exceed 8%.
Right. The judge was aware of that, but he was also aware that there was a means to waive those requirements through the so-called rural road alternative.
The judge, and that's where the judge actually erred in this particular case. The judge essentially concluded that the rural road alternative allowed the planning board to waive the requirements applicable to a Type A road. But the rural road alternative expressly prohibits the planning board from reducing the width of the roadway to less than 14 feet.
And it has to be 14 feet. I guess I'm getting confused because all of these references to subdivision control regulations. Does it have to be 14 feet even if it is just going to build a single-family home on this lot?
It does, Your Honor, and the reason for that is because the Cater parcel is landlocked. And so an access road has to comply with the requirements of the subdivision control statute, either because it's the lot to be used as a single-lot subdivision.
But what is a single-lot subdivision? What does that mean? That you just have one house on it?
A single-lot subdivision is essentially a lot in which the frontage that is required, in this case either 50 feet or 150 feet, is established by a roadway leading into the lot.
Okay. So this error that you say, this error that the judge made in assuming that the rural road alternative was available, was that at some point brought back to the attention of the judge? Because surely he didn't intend that there would be no access. I mean, he went to spend a lot of time, and everybody went to a lot of effort to sort of plot this road. Was this brought back to his attention?
It was not, Your Honor. It was actually never even raised during the course of the trial. There was virtually universal agreement that in order for the Caters to develop their lot, they would have to comply with the Truro subdivision control regulation, which in turn required that they construct an access road that met the requirements of what's called a Type A road, which is a roadway which has a 40-foot wide right-of-way, a 14-foot width, and a slope of no greater than 8%, except in certain limitations. And the town of Truro the planning board rather, has the discretion to waive all of those requirements with the exception of the roadway width. And that is expressed in the statute.
And does that include the shoulder width or just the roadway width?
Just the roadway width.
So the shoulder can be waived?
Well, the statute seems to suggest that any other applicable requirement can be waived, but it expressly reserves or limits the planning board's authority to waive the 14-foot roadway requirement.
But could waive the 40-foot right-of-way requirement.
Apparently. I mean, that's what the subdivision control regulation would suggest, certainly.
Going on the other part of the judge's decision, that is that there was no estoppel here. Apart from your clients, but the predecessors in title, and I guess it really is referring to the great-grandson of Mr. Cobb, or the grandson of Mr. Cobb, I forget which, but both the restatement, the first and the third, talk about, one of them explicitly, one of them in comment, about standing by and being silent when something is happening that may be inconsistent with the right-of-way or the easement. When the lots were being carved up and sold, next to Benson Road in the 30s and 40s, or 20s, 30s, and 40s, what do you say to the silence? I mean, it doesn't matter, or? And did the judge really look at that, or was the judge using a test that was something more like abandonment or prescription, loss by prescription?
I think you're asking me two questions, and I'll try and address them both.
Sorry, I probably am, but if you can separate them, that you're better than I am.
Just to put it in context, houses were built on the properties along Benson Road roughly between 1931 and 1969, so over a 30, 40-year period. I would suggest that comment G of Section 505 of the restatement, as well as Section 7.6 of the restatement, third, both address issues of what's called partial estoppel or a modification of an easement. And they both implicitly recognize that estoppel can operate either in whole or in part. In order for estoppel to apply in whole, or that is entirety, the intervening development has to be irreconcilably inconsistent with the continued existence of the right-of-way. And the court recognized that and used that language in finding that
you find that in the restatement that it has to be irreconcilably inconsistent with? I mean,
I'm
I
not
know
sure
the
that
court speaks about that, but do you find that in the restatement?
I think Your Honor is correct. I don't think that the restatement uses those precise words, but certainly Section 7.6 recognizes in language that, frankly, I can't relate to you, I don't have it in my head, but uses language that is, I would submit, the equivalent of that. That is, that certainly the Section 7.6 recognizes that so long as there is an opportunity to locate the right-of-way in a way that does not encroach upon the improvements in the land, that there can be modification of a right-of-way, but not entire extinction.
So, and in the judge's findings, he said that the construction of a house is not sufficient to constitute irreconcilable use. No. But what if a landowner had constructed a fence along his or her entire rear boundary? Would that effectively have amounted to adverse possession as to that easement?
I think that's absolutely correct. It could. That wasn't the case in this instance. There were houses that were developed, but even as the exhibits in the record illustrate, for example, the aerial photographs, as well as the various plans that were submitted by various parties in the litigation, indicates that there were a number of different routes over which the right-of-way could be fixed, even after the construction of houses on the different properties. And that's why the court found, and I think it implicitly applied the doctrine of partial estoppel in finding that the roadway could be located in any number of locations which wouldn't interfere with the quiet enjoyment of the homeowners that have come into the neighborhood in the meantime.
Now, why should we not simply say, we'll let the Truro Planning Board decide whether they're going to grant a rural alternative, and if that's the case, you have your right-of-way. They're not happy, but they have the least intrusive right-of-way that is reasonable, and just wait to see whether or not they do it. If not, it's remanded to the land court to figure out whether it should be larger or whether it should be not at all.
What I would submit that what the land court should have done is said to the Caters, you must build a road in compliance with local zoning and subdivision control requirements. Those requirements, the subdivision control regulations, take into consideration not only the kinds of factors that the land court used in reaching its decision, i.e. preservation of the environment and the existing topographical features, but that regulation also takes into consideration something the land court did not address, and that is the issue of public safety. And the subdivision control regulation says, among other things, that access roads must be sufficient not only to accommodate normal traffic, which a 12-foot road conceivably would, but also emergency vehicles such as fire trucks and ambulances and the like. And the court made no reference to that. So the problem is that the court has essentially, to put it candidly, put a gun to the planning board's head and said, you know, you must exercise your discretion and permit waivers of.
But is that really fair to what the judge's formulation of what his powers were here were more complicated than that, because he said, as I correct me if I'm wrong, that look, one of the things I can consider is that this road could have been built before the planning board statute was even enacted, and there could have been a road on the ground that was only 10 feet wide. There was nothing that the planning board could have done about something like that. So we could conceivably have a 10-foot road wide. And he said, I'm not going to do that because that's just not safe.
Well, you're right. The court did make that conclusion, and I'm not sure that the court cites the delay on the part of the Caters and their predecessors in seeking to develop the property. I don't think you're going to find delay in any of the formulations of either Section 505 or Section 7.6 of the
except
restatement.
in the context of silence.
Well, silence, but, Your Honor, it goes back to a question that you raised earlier, that I would submit that unless the surrounding properties were developed in a way that made exercise of the right-of-way infeasible, there was no obligation on the part of the dominant estate owner to say anything. And it's very clear if you look at particularly if you look at the aerial photographs, that there's plenty of room in Truro, in this neighborhood, to locate a right-of-way that would comply with the subdivision control regulations and provide the Caters with sufficient access to be able to develop their property and use their property for the purpose for which they purchased it. I see that I'm out of time, so I'll thank the court very much, and I'll rely on my brief. Thank you.
May it please the Court, I am Thomas Frassardi, appearing on behalf of the trustees of the Sylvia Clark Revocable Trust, one of the residences on Benson Road. I'm here today with Andrew Higgins, who represents the Clark's next-door neighbor, Susan Cabot, and also with Mr. Morrison, who is representing the Truro Conservation Trust. We have notified the Court that it was my intention to speak for 10 minutes to address the issue of estoppel, and after that yield to Mr. Morrison, who would address the subdivision width of the road issue, if that is acceptable to the Court. Thank you. We are here to ask the Court to adopt Section 7.6 of the Third Restatement of Property on Servitudes, and in particular, to apply the principle of estoppel under the restatement and declare that the easement recited in the 1899 deed has been extinguished on the facts of this case.
But what is that? Doesn't that leave the Cater parcel useless?
No, Your Honor, it doesn't. Certainly it's still valuable. It's several acres of coastal land in Truro. It's abutted by neighbors who do have access. In particular, there's the Thornley land to the north. The Court can see that in several of the trial exhibits. There is a subdivision road up to the Thornley land, which could be extended off to the Cater parcel. That would have to be negotiated. I mean, that's a private right. The Court cannot impose that on the Thornleys or require that Caters do that. But when the Caters bought the land, they knew that they would have to do something about access. And I would point...
They had access. They had it by deed.
Well, Your Honor, they had a deed that recited access, but that's not the same as having it. If by the passage of time and the occurrence of circumstances under principles of estoppel had extinguished the easement, then Mr. French had no easement to give to the Caters. I wanted to answer one question that came up during my brother's argument concerning how the Caters accessed their land the first time they went to see it, when they went to see it before buying it. And that may be found in Volume 2 of the Record Appendix, page 54. It's page 22 of the transcript there, lines 11 through 24. Dr. Cater's testimony was that he accessed the land that day by going up the Callender-Cohen driveway, the one from the southeast. So they went down Stevens Way and then up across the land from the south. Of course, Dr. Cater also saw that there were houses intervening between the land he was considering buying and Benson Road.
Mr. Edmonds says, yes, the restatement speaks of silence, which is, I think, where you're probably going, but it still has to be something that it's partial modification, and so he says that even under, at least this is what I thought he was saying, that it's going to be a question of whether something is basically, you can't do it. In other words, you can't accommodate the rest of these lots that have been developed if you were to build this driveway, that's what an estoppel would require.
Yeah, I think that the standard of estoppel is different from abandonment or adverse use in that you do not need to have a complete obstruction of the way. I mean, that would be impractical here. There were many acres initially burdened with this easement in 1899, as we cited in the deed. And, of course, the unfairness here is that the land was divided over a period of somewhat less than 100 years, sold to third parties, and there was no provision made during that process for where the easement would go, leaving the land court with a very difficult task, almost like pin the tail on the donkey, to find out which of these unlucky owners was going to be.
But when the titles were searched back, and even in the 1930s, wouldn't a lawyer searching the title and going back to the original Cabot parcel, only 30 years, have found the express grant of an easement?
I think Your Honor is referring to the original Baker-Cobb conveyance there, the 1899 deed. Well, perhaps in the 1930s, but certainly when the when the homes were being built in the 1950s and 1960s, they probably would have stopped the examination at the 1908 warranty deed from Mercy Cobb, who also signed the 1899 deed. The title standard under General Laws Chapter 93, Section 70, which really applies to certifying titles to mortgagees.
So who bought in the 1930s?
I think the record is incomplete on that point, Your Honor. I think that sometime around then, the heirs of Charles Cobb, Howard French, his mother Bertha French, had actually reacquired the Baker parcel. So part of the problem with appearance here in the estoppel is that during this long, long period of time, the land that was where the dominant estate was reacquired by the Cobb family, making it appear that this was all just one family's land and that there was no intention of developing it. And I think when we're looking
The Servient estate.
Excuse me, Your Honor, I didn't.
No, the dominant estate.
They purchased the dominant estate or the Servient estate?
The dominant estate. The dominant estate went out of Cobb in 1899, and then it was reacquired by Bertha Cobb French, who was Howard French's mother, and then ultimately sold to Dr. and Mrs. Cater.
Okay.
That's the sequence. And I will add that the record is incomplete in one way, that there's not the date of when Bertha Cobb reacquired it, but it's sometime during this long history. So it comes back into the Cobb family, now the French family. They own all that land. They own the parcel now owned by the Caters. They own the Truro Conservation Trust parcel, and they also own the Callender land. So it's a big parcel that they own. It all looks like one big open space with a house on it, to outward appearances. That's not what the records show at the registry.
Let me follow up on something that you said before. You said that when the Caters bought the property, they didn't buy a property with access, just the deed showing the easement, but that had been extinguished. On your theory, when was it extinguished?
Sometime between 1931, when the first house goes up on Benson Road, to 1969, when the last house is completed there. Certainly seeing those houses go in.
So over a 30-year period, it gets extinguished?
We could
All
argue
at
that,
once or little by little, or how does that work?
I think it gets extinguished because there's a duty, there's an obligation on the part of the dominant owner to say where they want this completely unlocated easement to run. Certainly by the time the Clark House is built in 1969, because that was the last clear corridor out to Benson Road.
Well, but the judge just found another one.
Well, no, he found a path straddling the lot line between the Clark and the Cabot parcels. But that's not the same. That's going across someone's land. In 1969, when the Clark House was built, that was vacant land.
So, all right. So if it's vacant land, then, does the obligation of the dominant estate differ?
I think it does, Your Honor.
So it's only when the houses are built?
It's as the houses are built, Your Honor. And what's important, of course, is during this entire long stretch of time, the land that the Caters now own is not being used at all. It's just open land, as is the land that is now owned by the Truro Conservation Trust. Also, to keep in mind, the terrain here is extremely hilly. So anyone looking at this land, especially from the Clark and Cabot parcels, looking directly back of it, and you can see this in the trial exhibits, would see a very steep slope. It's a 30% grade, not a grade that you would ever think of.
Up to the dune?
Yes, 60-foot total height, 30% grade. So it's an extreme grade. It's not a situation where you'd think there's a road coming through. In fact, if you're told there's a road coming through, you'd probably be skeptical. That's the appearance of the property. So what we have is a very long period of time where there's no activity on this dominant land, no established path for access. And that sent a signal to the owners along Benson Road that no one was doing anything with this land. And of course, that's assuming that they knew about the 1899 deed in the first place. But the signal that was being sent is that this parcel was not, that the easement was not going to be constructed.
And there was never a structure on the dominant estate?
There was never a structure
So
on the
no one
dominant
ever
estate.
lived there?
No one ever lived there, Your Honor. And no one ever lived on the land where the Truro Conservation Trust owns today. So that land has always remained undeveloped.
So this is a different situation than if there had been a house there and somebody living there and actually watching all of this happening. There was no one watching.
This is our point, Your Honor. You know, it's just the happenstance that the parties, the owners on Benson Road, did not erect fences is not a reason to run the road across their land today. That's just an accident of history. The fact is they developed these parcels and they did not expect a road to come through. One last word on partial estoppel. The court could also hold that this is just limited to a dirt road, unimproved altogether, since that was what was the intention in 1899.
Could I just ask you a factual question in terms of nobody was there? Does the record show, did the French family, couple, live in what is now the Calendar House?
That's correct, Your Honor.
So they're right there. They're just not up on the dominant estate.
That's right. That's right. It's just sitting there as open heath. It's coastal heath. Thank you.
Thank you, sir.
Good morning, Mr. Chief Justice and Associate Justices, and may it please the Court. I'm Chris Morris, and I represent the Truro Conservation Trust. I'm here today to address, as you heard, the issue of the scope of the easement. Mr. Forsardi and Mr. Higgins' clients both joined in this argument.
Can I ask you a question about something your colleague just mentioned, and that is leaving it or developing it, so to speak, as an unimproved road? That is an option? That could be done?
It certainly could be done. Yes, that's right, Your Honor. And
Under the zoning code?
but what could not be done is they couldn't get a building permit to build a house. They could build a path to nowhere,
Oh, I
a
see.
bridge to
Okay.
nowhere, as it were.
All right, that's helpful. Thank you.
I think it's important that you all know this case was filed before I started law school, and for the first 12 years of its existence, the underlying premise was that what the Caters needed was a 12-foot roadway, no more and no less, a 12-foot improved roadway. All of the exhibits, save one at trial, reflected a 12-foot roadway.
But I mean, that may have just been an error in not realizing what was required by the town of Truro, no?
Well, if it was an error, then it's Mr. Edmonds, Dr. Cater's burden to prove the reasonableness and the scope of his easement, and he utterly failed in that regard if that was an error.
Yeah, but the judge was exercising equitable powers in trying to identify the location of this road, and everybody had input on that, didn't they?
They did, but he could only do so on the basis of the evidence before him, and all of the evidence, including Dr. Cater's expert, testified that 12 feet was sufficient. In fact, that was the first question that Mr. Edmonds asked of his own expert, was to look at Exhibit 37 and ask him, does that depict a 12-foot wide finished roadway? He answered yes. In your opinion, in your professional opinion as my expert, is that sufficient for access for residential use? And he answered yes.
Well, but did anybody ask what the Truro zoning regulations were?
Yes, and the Truro zoning regulations were of record. They were in evidence. Others asked Mr. Donahue whether the plans that were in evidence complied in all respects with the Truro zoning regulations. And the answer in every case of every expert was no. Neither Exhibit 37 nor Exhibit 38, which are Dr. Cater's two proposals, complied with most or all of the Truro zoning regulations. There's no plan in evidence whatsoever that complies with those regulations.
But did anybody ever say that you need more than a 12-foot road width? You have to have a 14-foot road width?
And
No.
it's not waivable?
No, nobody ever said that at all. Again, the regulations are in evidence, but no expert witness, and there were several in this case, ever testified to that effect.
Do you agree with Mr. Edwards that it's not waivable?
Well, I think that whether it's waivable or not, I think the regulation certainly suggests it's not, to be fair. But whether it's waivable or not is not a question for this court. It's a question for the
I
planning
understand.
board.
I'm just trying to see where
Sure.
you're coming from.
I understand. I do think it's a question for the planning board, and that
So,
hasn't
but
been there yet.
so we could remand it to the trial judge. I mean, conceivably, if we agree with the Caters, and it could be remanded to the trial judge for a declaration that the road has to be 14 feet wide.
Well, no, I think what you would be doing there is disturbing a finding of fact, and there is no basis on which for this court to disturb
So
a
it could be
finding of fact.
remanded for further findings of fact.
No, I think I think the fair thing to do here is to affirm the decision. Again, this case has been pending a long time. There were 2 separate trials. Affirm the decision and let the planning board do what it will.
Which is to deny, essentially, engineer the denial of a building
Well,
permit.
that may well be, but there'll be an appeal from there. I mean, both witnesses
So this
who
case will
testified
continue until you die.
It may well, Your Honor. We have various bets on how that may happen, Your Honor. But I think that
Every 2 centuries, you have to have your Jarndyce case, right? And this is ours?
Exactly right. Exactly right. Both the 2 witnesses testified about what may happen in their professional experience before the planning board, and both Mr. O'Reilly and Mr. Brady testified that the planning board gives routine waivers of these various provisions, and that everything here is waivable. Now, again, the regulations state otherwise, but that was the evidence at trial. Both experts said these kind of things are waivable all the time. If you come in and you don't fit the scope, then they'll trade you for something else. There's no evidence that could suggest that there's no plan and evidence that would meet Dr. Cater's requirements. It was his burden to prove that, and he didn't put anything in evidence. Briefly, sorry, I lost my train of thought, Your Honor. At the end of the day, I will say briefly about Exhibit 38. Exhibit 38 is dated the day before trial. All the defendants objected to that. It was patently unfair. There were several rulings about when you had to disclose what the routes were and what their dimensions would be. We had the benefit of the fact that this was stamped by an engineer, so it was unquestionably developed the day before trial. Dr. Cater's counsel explained that to the court and said that that new plan, Exhibit 38, was animated not by some expectation that they needed to meet this rural road alternative, but by a desire to subdivide the parcel into more than one parcel. Now, that desire has been abandoned in this court in Dr. Cater's briefs, but it was clear that the land court took that exhibit for what it's worth and didn't consider that it was worth much of anything. Unless the court has further questions, I'll rest on our brief.
So just to be clear, all these high-paid lawyers and nobody is saying that, nobody tells the judge that the 12 feet is barred by law, barred by regulation?
Unfortunately, that's exactly right, Your Honor. The regulations were in evidence. The judge obviously is experienced in this area. But every witness who testified, and I personally asked the question of every expert, is 12 feet enough for this driveway? And every one of them said it was reasonable. And that was the standard the judge was asked to meet. He wasn't asked to define an easement that complied with the regulations. He was asked to define the scope of a reasonable easement. And in these circumstances, he considered the regulations, but he wasn't bound by them. And there's no case that this court or any other court has said that a land court or any other court limiting the scope of an easement is bound by what the local regulations
It's
say.
not, but at least as I understood from Mr. Edmonds, it's not regulation, it's by state statute. Is that right? The 14 feet? I thought that's what it
No,
was.
I believe it's in the subdivision regulations. I don't believe there's a statute to that effect. I'm not aware of
Iron
one
Man?
in the
Okay.
record.
Okay. Thank you, sir.
Thank you.